Hi everyone, welcome to this Mathys Squire webinar on patent drafting for success in Europe, which will be presented by Martin and David Hobson, partners at Mathys Squire. My name is Sarah Ismail, BD exec at the firm, and I'm delighted to be your host for today. Just a very quick introduction to the speakers today. Our first speaker is Martin MacLean, partner and UK European patent attorney who has a biotech background and has over 20 years of IP experience with particular expertise in patent portfolio management for corporates and government. Our second speaker for today is David Hobson, also a partner and UK European patent attorney with a background in biochemistry. He acts for UK and overseas biotechnology, pharmaceutical and food and beverage clients, as well as SMEs and academic institutions in all patent matters. So without further ado, it's my great pleasure to hand over to the speakers today to kick off the session.
It's Martin here. So good evening to our European participants and a good afternoon, good morning to colleagues joining from the US. Our presentation today is targeted at an informed user level and will therefore focus on what we consider to be the key issues in day-to-day drafting wearing a European hat. We plan to chat for around 30 minutes, after which we'll open the floor for a Q&A session. Just before we get cracking, I'd like to remind us of some of the key differences between US and European practice. And in particular, what's relevant today is inventive step. Inventive step. This assessment underpins any invention. It captures the inventive spark and reflects the unexpected technical contribution. However, our respective practices treat this quite differently. In the US, non-obviousness flows from asserting a negative, whereas in Europe, inventive step flows from a positive. So from a European perspective, I'd like to encourage you to be bold, assert the positives, and go on the offensive when drafting applications for Europe. I'll now hand over to David.
Hi everyone. We're going to be talking, we're going to be presented on four main topics. The first of those is when to file, which will focus on data considerations with a discussion of when the data package is adequate. Although this is of most relevant for the life sciences applications, there's a clear benefit for adopting similar considerations for all sectors and technical areas. The second part of the presentation will focus on the strategic use of the prior art. This is in the context of the background section of the application and its interplay with a summary of invention. And we're going to be discussing how this can be exploited to place the invention in the best possible light for a favourable consideration during prosecution. The third section is around tailoring the description for European prosecution. This is with a view to providing adequate written basis for amendments during prosecution and avoiding certain potentially terminal pitfalls that can arise. And finally, we're going to be looking at unity and how to avoid excess search fees. So, given the positive approach to inventive step in Europe, it's really important to consider inventive step on filing and when drafting a patent application. With this in mind, it's worth us having a look at the EPO approach to inventive step and having a quick refresher. So when assessing inventive step, the EPO uses the problem and solution approach, and we're just going to focus on some of the key steps there. The first step is to determine the closest prior art, so the most promising springboard to the invention. The second is to identify the novel feature of the invention, i.e. a novel claimed feature. And finally, to determine the technical effect or advantage associated with that feature. So in the life sciences sector, that third step will usually require experimental support. I'm going to hand over to Martin, who's going to talk through some specific examples.
Thanks, David. So let's apply these principles to a hypothetical scenario. Here we have an invention that relates to the control of house dust mites. So house dust mites are a domestic pest. They excrete DIR proteins, which constitute a major problem for asthma sufferers. whilst there are some remedies available, there simply isn't a universal solution. The key invention here is the use of a biological control agent, and that agent has the following positive attributes. It has a primary effect, it has a primary potency effect, and that is to selectively kill the target in question. And it has secondary effects. The secondary effects being, well, it's a living organism, so it's self-renewing and therefore represents an endless supply. It's also spreadable. It spreads throughout a colony of house dust mites. It's transmissible from one to the next, and it's transportable. So it'll be transportable from one colony to the next. So once in contact with the house dust mite, the agent will simply hitch a ride and end up wherever the target goes to, typically to another colony. So what data do we have here? Well, we're presented with two working examples that demonstrate the primary kill function. We have a fungus and a virus, and the data demonstrate the kill in vitro. Well, naturally, we would like to have a much broader claim than that. So we would like to have a claim that covers any acaricidal biocontrol agent for controlling HDMs. Question, do our data sufficiently support that type of a claim? So let's take a look. So the key question is going to be, what technical effects are required in order to fulfill the claim? And here we have a broad claim, simply use of the agent. So that's any agent, as long as it's a biological agent, and it has the acaricidal activity for killing house dust mites. So let's look at those key effects that we focused on earlier. So the first key activity is the kill. And we have two examples. We've got a virus, so it's a micro example, and we have a fungus, which is a macro example. Both of those biologics are demonstrated to effect the kill in vitro. So on the face of it, at least, it's perfectly plausible there'll be other categories of biologics that will provide that same function. For example, bacteria, protozoa. What about the second item? So we have the replication point. So the data also demonstrates that the agents can replicate in vitro. So again, we've got prima facie confirmation that the claim meets that requirement. So moving on to transmission, well, there's a slight leap of faith here, but on the basis that the agents were actually isolated from feces and or carcasses, there's a fair assumption there that the transmissible requirement is fulfilled. And I think it's fairly self-evident from what I've just said there about the isolation from feces and carcasses, that of course that the acaricidal agent will in fact be transmitted to new habitats. So on balance, I think all of the technical effects that I've highlighted there are sufficiently supported through the specific examples that we have. Naturally, additional examples would be most welcome. I mean, crikey, when can we never get enough data? Over to David.
So that raises the question of when is enough data enough? And we're going to be illustrating this with a simple invention here. So let's say that the invention surrounds cleavage of a polypeptide, secidine number 1, using protease A, which cleaves at an arginine site, resulting in 2 peptide products. Now, the typical approach would be, of course, to try and claim all arginine specific proteases and cover off the genus with a claim. However, what do we need in Europe to render plausible such a claim? So let's say an inventor comes to us with a single experiment showing that protease A is arginine specific, but even though multiple arginine residues are present in the substrate secidine number 1, protease A cleaves at one site only. based on this alone, I think we can agree that it doesn't render plausible the broader claim scope directed to any arginine-specific protease. However, it would render plausible a claim directed to the specific protease A. Now, this gives an opportunity for the drafting attorney to ask questions and be proactive. By this, we may be able to improve the applicant's position without actually needing to file additional data. A key question in this regard may be, how can we extrapolate from this specific data? Well, given that sec ID number 1 has multiple arginine residues present in its sequence, and only one is cleaved by protease A, we can conclude, therefore, that only one is exposed, and thus any arginine-specific protease would work, because there's actually only one site at which to cut. Now, if we've got that sort of statement in the patent application, we've got no additional data, but now we're in the grounds where we're arguably plausible. The icing on the cake, of course, would be something along the lines of modeling data to confirm that actually only one of those residues is exposed. And in this case, we're quite strong from a plausibility perspective. And I think this example quite nicely shows that you can be in a situation where you've only got data for one species falling within the broader genus, but it's possible to be in a situation where you've got plausibility for the genus as a whole. Okay, so having explored the principal considerations around sort of when to file and when is the plausibility threshold met, we're now going to move on to our second section. And this is surrounding the strategic use of the prior art. And all too often, we see that the background section of the patent application just includes a nebulous introduction to the prior art without any particular structure or purpose. And really, this is a missed opportunity. What we're recommending is that the background section should be seen as an opportunity to both educate and persuade the examiner and help put the invention and the art into its proper context. And with this in mind, a strongly constructed background section can impact assessment of inventive step and favourably skew the examiner's reading of the art. We'll now illustrate this with some specific examples, and I'll hand over to Martin.
So returning to the House dust mite invention, some of the prior art solutions that are available include the following. Typical washing, as one might expect, washing bed sheets, carpets. However, they're pretty labour intensive. So to say that, call out the shortfalls. They fail to deliver on these other items. They fail to prevent recolonisation. Chemical agents, that brings into consideration regulatory issues, efficacy in being able to penetrate heavily padded material, and to the extent biologics have been used, then we run into the problem of repetition and the need to continually reapply the agent. So all significant failings, and they nicely tee up the invention as presented. One can also use the preamble to help segregate technical fields. So quite often we'll be faced with problems in prosecution where an examiner wants to combine fields. And this is a great opportunity to try to preempt that. So for example, in the house dust mite example, well, mites is a genus, but mites comprise not only non-parasitic mites, which are what we're involved in, but also parasitic mites. And the environments within which these two critters operate is distinct. So for the purpose of this invention, we're talking about environmental scenarios such as bedding, carpet, etc. But for the parasitic mites, for example, scarab mites, bedbugs aren't even mites, they're insects. One is talking about a human body type scenario, so it's a method of medical treatment. So we're in very different areas. And at the level of taxonomy, there's a significant difference that can be nicely brought out. And once that's established, then there's a presumption of different inherent properties for the two classes, and therefore a lack of interchangeability.
Okay, and finally, the background can be used to establish technical prejudice and teaching away in the art. So taking this example, the invention's directed to a solid culture media that allows for screening of antimicrobials effective against Legionella. Now, this alone might sound a little obvious, but the art dictates the use of charcoal media. And this is because Legionella produces toxins as it grows. And those toxins actually produce its own growth. But the charcoal present in the media absorbs the toxins, allowing the Legionella to continue to grow. Problem with that media is that the charcoal also binds antimicrobials, therefore it's completely inappropriate for screening applications. So by pointing this out in the background section, we help avoid an examiner alleging that this is an obvious modification, and it nicely tees up our own invention, which in this case is directed to the charcoal-free medium. So to conclude, really, use the background section. It's quite often a missed opportunity, and there's a lot that can be done there to help assist prosecution.
So we're now going to take a look at the description and what we can do to improve the basic description. So we'll highlight a few important areas to consider when preparing this section. So first of all, we have the concept of tiered disclosures. Now, we will always start off with a very broad definition, but it'll often be the case that that broad definition lacks novelty, and we need somewhere to go to render that lack of novelty good. So the last thing we want to have to do is to go down from a genus to the species in an example, because under European practice, when one looks at an example, it's not considered to be a selectable group of items or individual items. It's considered to be a complete entity. So one can only generally take all of those items together. Now that's going to result in a horrible amendment. So we would encourage one to introduce a tiered structure.
So this is just an example for an E. coli protease identified, and this is sort of the sort of thing that we're recommending, from the very broad down to the very specific. Ultimately, I mean, it's just the opportunity of the drafting attorney to be creative.
So the same goes with fallback positions. So where we have created intermediate generalizations, sometimes those intermediate generalizations will be associated with particular technical effects. So it's important to make sure that one correctly links those intermediate positions to the correct technical effect. It might be a different effect, or it might simply be a scale of effect.
And you having that in the description serves two sort of key points, really. The first being the fact that it flags the inventive step to both the examiner and the prosecuting attorney, which can be helpful. But it also provides you basis to take that language out and put it in a claim, which you can't if it's just buried in the examples.
So when one is extrapolating from the key examples, we'll do this. But it's important to bear in mind there needs to be, or there should be, some rationale for doing so. So whatever the specific point is that's been focused on in an example, think about the technical or the functional aspect that component is providing to the broader entity, and feed that through to the markish group that one then creates in the description.
Explain it in black and white why it's plausible. In this case, which is using the previous example, they're all functionally equivalent to protease A. Just make sure it's not lost on the examiner.
So one constant bugbear under European practice is the fear of added matter when one is selecting from more than one list. David is going to illustrate how this comes to be and how an added matter objection arises, and more importantly, how to make sure this doesn't happen.
So this is a common scenario where one wishes to define two features of a claim, but where both of those features are present as parts of lists in the description. So in this instance, let's say we want to define the active form of the enzyme as sec ID number 3, and we want to define the protease as trypsin. This would result in two selections from two lists, the first being trypsin from the first, sec ID number 3 from the first list, and trypsin from the second list. Two or more selections from lists are considered to add subject matter in Europe, and if this happens, you're then, you've got a problem at this point. However, stating a feature is preferable individualizes that feature. So this removes it from the list. So in this instance, we state that sec ID number 3 is a preferable feature, meaning that you can select that. That's not considered to be a selection from a list, and only one selection from a list is required, i.e. that of trypsin. And in this particular case, there's no added subject matter. So really what we're trying to get across is it's always important to indicate key features to be preferable. Otherwise, you're not necessarily going to be able to rely on them for claim amendments during prosecution in Europe.
Parameters are extremely important. They help define boundaries. However, parameters can be meaningless in some situations unless the means by which the parameter is calculated or measured is also defined.
So this is a typical example, and something that we see quite commonly, especially in the antibody therapeutic space. For example, where an affinity parameter is present in a claim. It's really important to avoid reference to multiple and, in many cases, conflicting assays for determining a particular parameter. Instead, it's far better to be specific. And if you've got language in the description that's in the right sort of format, if there's any issue with regard to clarity of a term in the claim, you can just take that language out and drop it into your claim as a claim amendment. So now we're on to our final section regarding unity. So considering unity at the drafting stage is really important. In the absence of a clear structural or functional link between claimed species, a European examiner will, in practice, raise a lack of unity objection, and the search will then be focused on the first species only. To have the further species searched requires the payment of one or more additional search fees and or filing a divisional application to each one of those species. So in situations where one has a high number of species, for example, compounds identified in a chemical screen, this can be an extremely expensive process. However, there are steps that one can take at the drafting stage to help avoid this situation.
So let's take a hypothetical scenario. Here we have an invention that relates to the use of a synergistic adjuvant. The adjuvant improves the activity of a selective herbicide. As one can see from the illustrations there, the three specific adjuvants that we have data for are quite disparate structurally. There's nothing in common structurally, and that gives rise to a prima facie lack of unity. So what does one do at this point? Well, you can do nothing and you can accept the unity objection, or you can dig a little bit further, interrogate the science, engage with the client, ask the questions. So what are these compounds doing? What are these adjuvants doing? Well, it's pretty clear they're increasing water retention capability of the cuticle. And with greater water retention, that's leading to the increased herbicidal penetration. So how can we capture that? What can we do to define that? How do we know which compounds provide that activity and which don't? Well, clients can also be very helpful and can provide the right information. And knowing that a particular parameter, in this case, the HLB value, is something that is highly relevant here, allows one to craft an artificial definition around the key compounds that brings them together. And as it happens, all three of these adjuvants, because they're acting in a similar way, they all have an HLB value that is at least 10. So that allows one the opportunity to reunify what was previously a disparate group. And thinking of fallbacks, the HLB value does differ according to the different categories of adjuvants. So we have the three different categories there. But what this then provides is the opportunity to provide sub-ranges for each of those categories.
So in summary, we highly recommend a consideration of inventive step prior to filing.
Use the background as an opportunity. Don't think of it as just a placeholder and something that one has to fill. Take it as an opportunity. It is an opportunity to groom, if I'm allowed to say that, to groom the examiner into your train of thought and to educate them how you want them to be educated on the case.
Draft the application with Europe in mind. Be creative. Speak to the inventors. Try and work out what those intermediate positions are. It's going to help you during prosecution.
Don't walk into the traditional problem of selection from lists. Preempt it. Use preferably options.
Clearly define any parameters used. Put a specific assay in the description, and you might be able to use it later in the claims.
Where you have a prima facie unity issue, think outside the box. Try to think of other functional activities that will do the job. Don't sit there and just wait for the unity objection to hit you.
Okay, well, thank you very much. That concludes our talk, and we look forward to receiving your questions.
So I've got one question here. This is, how might priority consideration impact your decision on when to file? Okay, David, do you want to take that or do you want me to?
Why don't you take that one?
Okay, so I would liken this to the difference that we illustrated with on the one hand, the house dust mites. So there, I think all requirements of the claim, all effects that were required to deliver the claim were met by those two examples. However, one can never get enough examples. So if you would like, I consider that to be a gradual or a gradient type question on sufficiency. So I would think the priority date is met, sufficiency is met at the priority date, but by adding the examples, you're increasing your chance of any shortfall being met at the PCT filing date. On the other hand, however, when one considers the situation that David described, where there's missing information, I don't think one can make that information good unless you have that information. So I would suggest there are two differences there. It's more of a binary type sufficiency assessment, the second example. Okay, there's one here. David, do you want to take this? It's when the Europeans use the term technical effect, is that the same as new result as used in the USA?
I'm not specifically familiar with the term new result under US law.
Is that a Trump term, David? No.
But I can give you a bit more background on what a technical effect is. A technical effect really is the advantage. It's something new that flows from your novel feature and provides something unexpected versus the prior art. So taking the protease example, a technical effect may be the fact that a specific protease with a specific sequence has improved activity versus a protease having a slightly different sequence. So that's what we mean by the term technical effect. And it has to be something that flows from your point of novelty.
Right. And one more question here. Could you explain how to provide a tiered disclosure again? How is this beneficial? Is it to avoid the bar against selecting from two lists? Well, no, it's not. It's not to avoid the bar from selecting from two lists. It's when you start off with a broad grab. So let's take the genus animals, but your invention is really about rabbits. You would want to put in some tiered structures between the very broad grab animals and then the very narrow grab rabbits. So you might introduce something along the lines of animals with 4 legs. That might help provide a position when the first definition falls for lack of novelty, but yet the intermediate position wouldn't. So you end up with a broader definition than you would otherwise have if you went straight down to rabbits. David, can you see that next question? If we have a statement.
So if we have a statement to try and extrapolate out to broader scope, and the examiner does not believe it, can we present post-filing declaration, e.g. application does not have structural data in your example of the protease that cuts only at surface exposed arginine. Do you want to take this, Martin, or shall I?
Yeah, you take it.
So if the examiner doesn't believe that we're plausible, we're in a difficult situation then. There's interesting case law in Europe in terms of the fact that one has to be plausible before one can include post-filing data to be able to provide evidence of the fact that the effect is achieved. So what this means in principle is you have to overcome sort of the basic bar for plausibility. You know, is it more than likely that it's something is going to work? And in an example such as that one, I think we're in a good situation because everything in that specific example is pointing in the right direction. From a practical point of view, it's always worth trying to file a declaration with that data in, not least from the fact that the examiner will have seen it. So there's a psychological aspect associated with that. So the examiner is going to have seen that data and can't unsee it. So, I mean, our recommendation in that sort of situation would be always to try and file a declaration.
Agreed. One more question. When can a functional feature in a claim overcome a lack of unity rejection? Do you need to show that one could determine a priori that a given structure would meet the function, e.g. in your example reciting HLB greater than 10, are data required in the spec showing that each member of the genus meets this requirement? I think not. I think the disclosure of HLB and its interplay and I think you would have to define a de minimis number for HLB by which to set your standards, but I don't think you would need to actually have that information in the spec for each of the adjuvants because it's inherent to the adjuvants. What you're providing is the knowledge that HLB is an important and unifying feature. So no, I don't think you'd need all the data in the spec. Obviously great if you do, but I think you could provide that later.
Agreed, it's a matter of fact.
Okay, one more. Regarding selection from different lists, what if you recite each of the elements of the lists separately, In your example, you referred to sec ID number 3 as a preferred sequence. What if you state in an embodiment, the sequence is sec ID 1. In another embodiment, the sequence is sec ID 2. Okay, and so on and so forth. Would it be acceptable to introduce any of the sequences into the claims in combination with another feature listed elsewhere? Crikey. An interesting circumvention. I suspect the problem with that is that all of the sequences, although in separate sentences, they're all presented at the same level. So there's no pointer to pick out one rather than the other. So I think you would fail on that point. David?
Yeah, completely agree. And actually, this is, excuse me, this is something that we see in practice. The examiner would see that as a list, irrespective of having written it in separate sentences. Another way, of course, to individualize it would be to put it into a dependent claim. This would take it out of the list.
So we have one more question here. What kind of support do you need in order to extrapolate to all more species of a genus? Simply that it is plausible that the data for one species would apply to the other? Do you need to state in the spec that it is expected that they function equivalently? David?
So, sorry, I'm just reading your question again. There's 3 questions. So what kind of support do you need in order to extrapolate to all more species of a genus? It's quite difficult to give a specific answer to that because it's always going to depend on what the specific invention is, and how predictable it is. If you've got some sort of underlying structure or structural feature that you can show is shared amongst the different members of your genus, then you're in a really good position to be able to have little data and be able to extrapolate to the entire genus. If you don't, and they're all very disparate, then you're definitely going to struggle. Response to the second question, simply that it is plausible that the provided data for one species would apply to the other species. Well, you need some sort of technically credible rationale for making that assumption, and sort of mere assertion without something to back it up and decent technical reasoning, you're not going to be able to do it just based on that alone.
Agreed.
And regarding the third question, do you need to state in the spec that it is expected that they function equivalently? Well, if you don't have data, then yeah, I definitely would state that in the spec, because, well, the more that you've got, the more likely you are to overcome the plausibility threshold.
Yeah, I think there's a question there about being in possession of the invention at the filing date as well. So if you're faced with a position downstream where you're filing declarations to fill in those gaps, then I think that the more you put in the declaration, the more you're kind of undermining that you're in possession of the original concept. How are we doing for time, Saba? We've got one more question here. Do you think that the EPO will ever become less strict with respect to literal support and become more like the US in support requirements? Crikey, well, I jolly well hope so, because it is incredibly frustrating when one can see a damn good invention in a patent application, but for whatever reason, just the right support, because the relevant prior art that's causing the problem wasn't known about, and therefore we've gone straight from what was a very broad grab down to a very narrow grab. Yeah, I jolly well hope so. I don't know whether we are going to see anything.
So we've got another question here. What can be done in cases where we have lists in the spec, but no preferred language? Have you encountered successful ways to get around this? Yes, we have. And And the best thing to do in that situation, if you can get away with it, is take the entire list, or the entire list bar one or two elements, assuming that doesn't leave you with, one thing left. Let's say you've got a list of 10, taking 8, taking 9 of them, you're probably going to get around any added subject matter objection. And we have had success with that. And that's definitely what we recommend in a situation where we might encounter the selections from lists.
Yeah, when I've had that, I've tried to present that type of an amendment as a voluntary cancellation of maybe 1 or 2 of the items in that extended list. Another angle might be if there are any data in the spec that show a preference towards 1 or 2 in that list, one might be able to lean on the data to help steer you towards the preferred embodiments in that list or the preferred species in the list.
Can you simply put all items in a list as being preferable so as to be able to mix and match those items from another list?
Well, I think the point of the preferable language is to set things at a different level from the rest of the list. So putting everything as a preferable, unless maybe you're going to have something that says more preferable or even more preferable, I think you're going to struggle with that.
Yeah, and that's an interesting question as well, where you've got something where you've used, you've got your sort of broader list type disclosure in one embodiment, it's 1 or more selected from the following, and then you have preferable, then you have more preferable. In reality, that bit that's in the preferable bit isn't particularly useful. It's somewhat it's somewhat individualized, but if that's a list in and of itself, you sort of get into the point where there's a question about whether or not that's particularly useful, unless of course you do as we've just said earlier, which is take all of the members of that list. In that case, the only one that's going to be individualized would be the one that says more preferably before it.
Brilliant. I think that's all the questions that have been asked. And just to really kind of wrap up right now, and to say, oh, apologies. Actually, no, there was actually just one more question right at the end. Sorry, okay. We do have time for it, so I'll just.
There's one that says thank you.
Yeah, I know.
Could we say a believable description is more plausible? I don't know what a believable description looks like. If we just call it that, I think you have to look at what's disclosed. Everything's going to flow from the data. So what you actually have demonstrated, and where you can go from there, you can be creative as an attorney, but you can only do so much.
Brilliant. Great.
I don't know what a believable description is. Maybe if you can check in with us offline, we'll try to help you on that.
Brilliant. Thanks, Martin and David. Just to say thank you to everyone online that joined the session. Really do hope you found the webinar useful. Just to mention that you will be redirected to a feedback form. As always, would love to hear your thoughts about about the content of this session, as well as what you'd like to hear from us in the future. And lastly, as you can see, there's David and Martin's email addresses. So if there are any further questions or follow-up questions that you have that weren't answered today, please feel free to email them directly, and we can set up a call separately. And just finally, just to say thank you and take care. Thanks, everyone.
Thank you, everybody.
Yeah, thank you. Having a great evening. Good night.